Just another quick reminder. We have bagels, refreshments.
Thank
help
you,
yourselves.
Eric.
Haven't already overeaten.
If you get awarded attorney fees, does that go to the legal, like the
It goes to our organization.
organization?
yeah, yeah.
As like an aspect of grant funding kind of thing? Or is it
Kind of.
expense for your
It goes to our general fund.
general fund?
Yeah, but
Okay.
there is a Vermont Supreme Court case that says that even though we don't charge our clients fees, because
Yeah.
all of our services are free.
Right,
If the statute or a contract allows for to us to get attorney's fees, we can get them. And sometimes we have, doesn't
okay.
happen often.
And that also applies for like pro bono attorneys?
Yep, that applies to
That-
pro bono attorneys as well.
If
Yep.
they get attorneys, it goes to your.
Yeah. It
Okay,
goes to our general
Okay.
fund.
thank you.
Are we recording?
Yes, we are.
Awesome. Welcome back, everyone, to our subsidized housing training. I am Bradley Showman, staff attorney, pro bono manager, Legal Services Vermont. And I'll allow Eric to introduce himself.
Good morning, everyone. My name is Eric Fanning, and I'm also a staff attorney at Legal Services Vermont. And I appreciate you all joining us.
All right, next slide here. So topics for today. This is about an hour and 15-minute presentation, but the number of slides is actually higher. So we've got to be on top of it.
Gonna be moving quick.
Yes, and, but the design.
Hey,
of this presentation-
Bradley,
Yes.
sorry to interrupt. It might just be me, but I can't see the slides on my end,
Okay.
virtually.
We will try and fix that.
How's that? Can you see them now?
Perfect, thank you.
Okay, great. Thank you.
Thank you so much, Julie. Appreciate it. So the design of this presentation is similar to the design of the last presentation, where we give you citations. We might sprinkle in some court cases in there to show you where the statutes live. We'll highlight some issues that are relevant to our clients. And we'll take it from there. So let's go on to the next slide. So this presentation will give a broad overview of federal subsidies generally. We'll give you a pretty in-depth coverage on housing choice vouchers, formerly known as Section 8. And then we'll give you a slightly more cursory overview of low-income tax credit housing, LIHTC, and project-based Section 8. And a touch of special eviction protections for clients in these situations. Mostly, we're going to be focusing on how the subsidy works and how that affects the landlord-tenant relationship and those responsibilities. Next slide here. Just some key terms, because this is when we're working with government, it's federally subsidized housing. It's a government program. All these have involved the government in some way, the federal government in particular. There's going to be word and letter salad throughout. So if you're not familiar with subsidized housing, the big ones that we might say are PHA, or Public Housing Authority, the Vermont State Housing Authority, which is the primary PHA for Vermont for if you don't, we'll show you, but if you don't already have a public housing authority, and then HCV, or Housing Choice Voucher. I usually just call it voucher. Most people will call it Section 8. At what point are we going to stop calling it Section 8? Who knows? It's been HCVs for years, but we still call it Section 8.
Probably never.
Yeah, it's same thing with food stamps. It hasn't been food stamps since like the early 2000s, but we still call it food stamps. So I don't think it'll ever actually change, but I usually just refer to them as vouchers. And when I say voucher, I mean the housing choice voucher. And then just some other terms: good cause, termination, reasonable accommodations. And the Vermont Housing Finance Agency comes into play a lot, administering the LIHTC tax credits. And next slide, please and thank you.
Okay, so first substantive topic we're going to cover today is, what is a federal subsidy? What do we mean when we refer to a subsidized tenancy or federally subsidized housing? So if we can get to the next slide here, Maya. It's a little chart just to kind of boil down to the essentials, who's involved in the housing situation. And of course, as you could see in the private market, as you learned from the previous presentation, when there's just a regular landlord-tenant relationship, the relationship is solely between the landlord and the tenant, basically. where you have a federal subsidy, the government is an active participant in the relationship. And they're actually, in all respects, a party to the contract. Because when the housing authority issues a voucher and a tenant leases up with a private landlord in a Section 8 situation, the HAP contract that is signed by the landlord and the tenant is, signed by the landlord is also a contract with the government. So they are a full active participant in the contract and a party to the contract. When the government is involved in something, you can be guaranteed there will be heightened scrutiny. They have skin in the game, a lot of money going out the door to private landlords. So they want to make sure that the standards are being met, the rules are being followed, so on and so forth. The scrutiny basically is put on both landlords and tenants. So landlords have to do things like make sure that the unit is safe and clean and fit for human habitation, provide reasonable rent, notify tenants of their rights in certain circumstances. Tenants, on the other hand, have to follow more rules to remain eligible and to remain in compliance, like reporting their income regularly, limiting who lives with them. And this is something that's actually enforced pretty rigorously. Once the household is defined, the tenant has that limitation on who can live with them. So the federal government subsidizes rent for special types of properties or eligible low-income tenants. So how this works out when the tenant moves in and leases up is that the subsidy keeps the tenant's effective rent at 30% of their income. In some cases, it can go as high as 40, but in no case is the tenant supposed to be paying more than 40% of their income towards the rent. And in general, when you hear about what's affordable or unaffordable, what we're talking about in most cases is if you're paying more than 30% of your income towards the rent, whether you live in subsidized housing or not, it's considered unaffordable. So the government subsidies keep it at that affordable rate, or at least that's the idea. Tenants have to meet certain requirements, such as income limits, and they have to recertify their income annually. So once they're in, they have to continue to demonstrate to the housing authority that they continue to meet income requirements. And the landlords have to continuously certify and show that their properties meet the standards like health and safety, housing quality, rent reasonableness, things of that nature. The subsidy can be tenant-based or project-based. So when we mean tenant-based, the subsidy goes with the tenant, meaning, in the case of a Section 8 housing choice voucher, it's portable. So if the tenant decides they want to move and are allowed to move, because they're not, always allowed to move out, but say they are, and they find a new apartment they want to lease up at, they take the subsidy with them, and it's applied to the new unit. The new landlord would sign a new HAP contract, and the subsidy would attach to that new apartment. There's a few other kinds of subsidies that we list here. Shelter Plus Care has more wraparound services for folks who qualify. The HUD VSASH vouchers are for veterans who are low income and require assistance with housing. HOPWA is one for folks with HIV and AIDS. So just a few different examples there. Then we list a bunch more. There can be subsidies that are site specific, and that's on the other hand, the tenant can't take the subsidy with them if they move. It's it runs with the land, so to speak. It's tied to the dwelling unit, so the tenant can't move out and keep their subsidy unless they get a subsidy from somewhere else. So how to apply? The tenant can apply for tenant-based rental assistance with the Vermont State Housing Authority or any of the local housing authorities throughout the state. And later in the presentation, there's a list of all of the housing authorities that are in the state. So you can apply directly with the housing authority. Also, community action agencies can help do applications. So, you know, those are regional throughout the state as well. And someone who can go to seek the services of like housing navigators there, and they can help with applications. In the case of tenant-based subsidies, there is a wait list, or at least you can only apply for a Section 8 voucher if the wait list is open. The housing authorities make announcements as to when they're closing or opening the wait list. I'm not sure if they're required to do that by law. I suspect they are, but in any event, you know, a practice tip is to pay close attention to any announcements concerning closing the wait list or opening, because that could really impact a client's tenant's chance of getting subsidized housing. To apply for site-specific authorities, you go to the housing authority who manages the property or owns the property, and apply directly through them. And as you can see in the slide here, it's typically no wait list for site-specific subsidies.
There's no wait list, but it doesn't mean they're available. Right?
Yes.
Yeah, yeah.
The unit has to be
Yeah,
available.
right,
If the,
right,
if the
right,
unit's
right.
available, there's
Right.
no wait list. You just apply for the unit, and you know, if you're accepted, you get the subsidy and move in. So
More luck of the draw in that situation.
yeah. So that's where clarifying rather.
So for the reference guide for housing choice vouchers, there's your statute. You want to look at public housing authority administrative plans. Those are usually available on the housing authority's website, but some of them make you ask for it. And you know, I guess make you ask for it sounds like they're, you know, like making it difficult. They just don't have it on their website. But usually if you ask for it, they'll email you a copy. The HUD handbook has a lot of additional detail about how to administer the housing choice voucher. It's linked there, and the public housing authorities in Vermont are listed there. I like to make a joke that like every 10 people in Vermont gets their own housing authority, because it's like there's so many of them for a population. I think we have like 650,000. But if you're living in a locality that has a housing authority, you know, that's where you would apply for the subsidy in that area. Otherwise, if you don't live in one, it's the Vermont State Housing Authority.
Also, if I could just add something really quickly here, you know how we love acronyms and abbreviations. If you're referring to BHA, pay close attention. There's tons of a few BHAs. Folks may not know which one you're
Yeah.
talking about specifically if you say that. So our colleagues down in the Rutland, Bennington area get really upset.
Yeah.
when we refer to BHA and we're talking about Burlington Housing Authority. So just want to mention that.
Yeah, it's always, you know, like I said, with government, you know, it's easy to like turn something into an acronym salad. And so we try to be really mindful of being specific with our language. And BHA is definitely one of them.
We're lawyers, we're law students. We
Yeah.
love word salad.
Yeah,
We love
yeah.
acronyms.
Speaking of salad, LIHTC, low income tax credit, how? Yeah, there's a statute there, and the federal regulations, IRS guidance. The Vermont Housing Finance Agency has the Qualified Allocation Plan, the QAP, and the Advocates Guides to Tenants' Rights in low-income housing program. It's a resource guide, not a source of law. We'll go into a little bit more detail about LIHTC later on in the presentation, but basically it's a tax credit. And so that's why you see a different administrative agency like the Treasury as opposed to HUD. So it's the Treasury that administers this program, and finance and tax related agencies that administer this program, as opposed to housing related agencies that administer this program. That makes it kind of interesting. We'll go on to the next slide here. And then project-based Section 8, it is similar to Section 8, except it's site-specific as opposed to, you know, a voucher person-specific. There's a statute, there's the HUD regulations. The HAP contract is a source of, you know, a legally enforceable agreement. We'll go into what that is. And then the HUD handbook as well. All right, and how to determine if a unit is subsidized. So more often than not, a client at your initial interview is going to be able to tell you that a unit is subsidized when they tell you that their rent is about a third of their income. So that's a good idea. to give you a hint that something is subsidized. That's not always the case, because sometimes, especially with LIHTC, if the rent is tied to the property and not necessarily to the tenant's income. And so the rent in those situations might be higher than 30% of their income. And more often than not, a client is going to be able to tell you they have some kind of low income housing. They might not know the actual acronym. The lease should be able to tell you. Sometimes it doesn't, which is interesting. So you can actually look this up online and housingdata.org, which is administered by the VHFA. They'll tell you if you can look up an address, and it'll tell you if like how many units are subsidized, and what kind of subsidy that those units have. You'll learn in the LIHTC that maybe not every unit in a building will be subsidized, so it won't necessarily tell you if your tenant's unit is subsidized, but it will tell you if there's a subsidy in that address. And then check the pleadings and notice if it's gotten to that stage. Next slide, please, and thank you. Reasonable accommodations. Okay, so one key piece of advocacy for subsidized housing is that just about every rule is subject to a reasonable accommodation if an applicant or participant's disability creates a barrier to access or participation in the HCB program or any of the other programs. So here's some examples of things that I've been successful with in asking reasonable accommodation. Increasing the payment standard for allowable rent above fair market rate. Justifying non-payment of rent, like medical expenses or other disability based reason for why a person couldn't pay. A justification for a late appeal. So you'll learn that if your subsidy is being terminated, you only get like 10 days to appeal. And so some folks might have a disability that impairs their ability to respond that quickly. And then violations of the lease, like having guests for too long or not being able to control guests' criminal behavior. That one's not mine, that's case law. You know, if certain violations are related to a person's disability, such as they're being taken advantage of because they can't force someone to leave, because maybe they're bedridden, maybe they don't have capacity to actually kick someone out and they need help, that could be a reasonable accommodation to violations of that guest policy, or someone is taking advantage of them by living in their unit.
What does that mean, increasing the payment standard for allowed?
We'll go into that. That is a good, because that's the word salad stuff that I try my best to avoid. I will go into how rent is calculated, and sometimes you might need a reasonable accommodation because I'll show you.
Okay, sure.
And so we're not going to discuss reasonable accommodations in depth, but it's important to interview your client for a possible reasonable accommodation if they're having trouble with the HCB program or any federally subsidized program. Another good source of advocacy is, thank you, the VAWA Act, the Violence Against Women Act. So clients may have a disability, a domestic violence related reason for why they can't comply with certain aspects of the HCB program. I keep saying the HCB program, this actually applies to any covered housing program. So it's the vast, if not all, the vast majority of federally subsidized housing. VAWA is its own statute and its own regulations. It applies to any covered housing program. So like I said, just about any federally subsidized housing program. It requires owners and covered properties to notify tenants of their rights in VAWA when terminating the tenancy. And public housing authorities can't terminate assistance if the underlying reason is related to domestic violence. This is a super broad standard. Related to domestic violence is not just A to B. There might be a lot of underlying issues that affect a person's ability. And the Violence Against Women Act applies to men and women, even though it's called the Violence Against Women Act. Men, women, and non-binary people. So there might be a lot of underlying things. We go into more detail about this later in the presentation that prevent a person from complying with their obligations, right? So For instance, if, someone is being forced, someone might be failing to pay their rent because they're not allowed to work. And that might be a result from, domestic violence or control of a different person. And that might justify the non-payment of rent and help save their voucher, if that's the underlying reason. We'll go into more detail about that. But what I would really encourage folks, once I do send you the slides, is to take a look at the HUD's guidance for Violence Against Women, Reauthorization Act of 2013. This is guidance directly from HUD. It's current as of today. We looked this up, but there might be an update forthcoming. But it goes into really intricate detail of what might be related to domestic violence. And it's a lot broader than you think it is. And if it can mean the difference between saving someone's subsidy and not saving someone's subsidy, it's a great thing to keep in mind when interviewing your clients and they disclose to you that they're going through something because of something related to domestic or dating violence. And that might have an impact on their ability to participate in their housing the way someone else would. Next slide, please, and thank you. All right.
So next we'll talk about issues with housing choice vouchers, or as they're also known, Section 8. They're interchangeable, but the term that's used today is housing choice vouchers. So common issues, applying for the voucher, getting the subsidy, finding an apartment to lease up at, leasing up, and housing quality inspections. They play a role in where the tenant can live, if their apartment will be approved or not. Rent calculations, annual recertifications and inspections. So this basically means maintaining eligibility, keeping compliance, and termination, removal from the program.
There we go.
So as I mentioned before, the wait list has to be open first, and here's the federal regulations site. Public notice is required, so that answers the question I raised on my own before. So the public has to be notified as to when the wait list is opening and closing. You have to apply to be on the wait list. So here's one thing to keep in mind when you're dealing with clients who have applied before and they're on the wait list. They may be periodically contacted to update their info so they know how to be reached. So this is something I try to drive home to folks. Yeah, they might not be called up on the wait list right away or anytime soon, but they really have to let the housing authority know if their address changes, phone number, contact info, because if they do get called up on the wait list and the housing authority can't reach them, that's it. They're just going to move on. And the person loses their place in line. So just one thing to keep in mind. As you can see here on the slide, a few things, issues that may pop up. Denial to be on the wait list is subject to an appeal called an informal review, and we'll talk about what that means later on. Removal from the wait list can be contested with a reasonable accommodation. So, for example, the disability for any reason prevented the client from either, contacting the housing authority in time or updating their contact info. A reasonable accommodation could help them get back on the wait list or moved up on the wait list. Removal may be subject to informal review. When in doubt, ask. It's not quite, crystal clear in the regs if that is subject to informal review. But if there's one thing I've learned from, practicing law these past few years is that you're not going to get something if you don't ask for it. So just ask when in doubt. And then once approved, the tenant will be issued a voucher, which is, basically a piece of paper saying you qualify, and the tenant can then go looking for an apartment, go shopping, as it were.
And this is a plug to follow us on social media, like Facebook and things, because we announce these as well. Like if the thing is up, our website will announce it. And so we try to get the word out when the wait list is open, because that does happen so infrequently. It's like, the wait list is open, guys, let's go apply.
Thank you for mentioning that, Bradley, because I'm not on Facebook and I would not have known that.
Our website, BT Law Help, Legal Services,
There you go.
BT.org, all of it, that will have it up there too.
I have a quick question.
Yeah.
So is it like open, like to the nation, or is it dependent on the state?
It's statewide. Or it might be, like the Burlington Housing Authority might have their wait list open, Vermont State Housing Authority might have their wait list open, and then you can apply to be on their given waiting lists.
There's no like statewide announcement per se, like here's all the housing authorities that have their wait list open. That doesn't really exist. Each housing authority publishes their own. notice.
And you can apply to be on someone else's housing authority wait list even if you don't live in the place, right? They might
Yeah.
give you a locality preference to move you up. So if you live in Rutland, but you apply for Burlington, Burlington might have a locality preference to preference people who are already living in Burlington. But you can apply no matter where you live.
Another practice tip, when I'm speaking with a client who's, trying to find housing or trying to find a subsidy because they can't afford their apartment, I'll often, advise like a, catch-all approach or leave no stone unturned. Like, okay, you applied for Vermont State Housing Authority. What about Burlington Housing Authority? What about Winooski
Right.
Housing Authority? What about Montpelier Housing Authority? If you don't mind moving to Washington County, leave no stone unturned.
Yep.
Next issue here, there's an expiration to the voucher if the tenant doesn't lease up. So that's another thing to pay close attention to. If you're dealing with a client who happens to be experiencing homelessness, but is on the wait list or, actually was approved and got a voucher, I should say. The requirement is that they have to find an apartment and lease up within 60 days. That doesn't sound like a lot, does it?
I know, right?
It's not a lot.
I thought it was.
No, so here's the thing. The tenant can request an extension, and this is mostly discretionary. In my experience, and Bradley, maybe you can say, maybe your experience is different, but in my experience, housing authorities tend to grant one extension basically as a matter of course. I've never heard of someone getting denied an extension flat out.
Right.
So usually they'll get one and maybe it'll be an extra 60 days and at
It'll
30,
be-
60 days.
This is a place where you definitely want to take a look at the administrative plans for each of
Yeah.
the housing authority that you're looking at, because they're different. So some are 30, some are 60, because it's discretionary, right? So it's not mandated by federal law.
Right.
And they'll give you one as a matter of course, like Eric said, and then probably won't give you a second one unless you need a reasonable accommodation.
Right.
And
Maybe if there's other extenuating circumstances, maybe Wawa comes into play, but
Not just the housing market,
Sucks.
us.
right,
no, 'cause
Right.
Not good enough.
they know that and they don't care.
it's
Sometimes.
it's heartbreaking when someone has a voucher and they're about to get housing security and they can't do it. And that's one that I'm like, oh my God.
I think
that
from
hurts me.
Yeah, from the PHA's perspective, maybe they're just getting impatient, like, come on.
Well, so the perspective, and part of this presentation is just to kind of emphasize the role of the federal government in this. And part of the perspective is like the federal government has requirements that it's like, you got to use the statute, but you've got to use your voucher. We're going to do this. If you can't use it, we're just going to give it to someone else. And it's
Yeah.
very it's government, right?
Mhm.
And it's very,
By the book.
it's very by the books. The housing authorities have HUD requirements. I've had directors of housing authorities in my experience talk to me. They're like, HUD is breathing down my neck to get this done, to move these vouchers. I don't have, I'm gonna get sanctioned if we don't do this. And that's their perspective. I don't think that's actually gonna happen. But,
That's what
I
they
mean,
say.
it could, and I do believe that HUD does kind of breathe down the neck of a lot of housing authority directors. Because they want to administer the programs efficiently. They don't want people just sitting on vouchers. In my point of view, I mean, that's one of the things to me, it's just an unmitigated tragedy when someone has a voucher, they're this close to being housing stable and they lose it and there's nothing you can do. And
And then they're thrust
I know.
even deeper into the cycle
Yeah.
of poverty because
Yeah.
now they don't have a
Yeah.
voucher and therefore housing's gonna be that more
Yeah.
unaffordable and
Yeah.
it's,
Yeah.
yeah.
How
But they
bad is
can
that?
reapply.
they can reapply,
But then you're on the wait list.
Right,
again.
right.
Yeah.
I mean, at this point, with the low availability, is that happening all the time? Are people using these?
So we don't hear about it a ton.
Okay.
That's, we don't really intake them either, right? I don't think that we're necessarily looking for these cases either. I think recently we have been, but
Based on our observations, think I can say it's not happening often, or at least we're not seeing it.
Yeah, yeah. So I do think people are able to use them more than you would expect. But when we do hear about people, it's one of the things, like a lot of this, being a legal aid attorney is tough. And this is one of the things, being an attorney generally is tough, but this is one of the things when you're actually facing poverty, you see an off ramp to poverty and then there's a detour and it just sucks.
Well,
and I get it, but
And another thing too about being a legal aid attorney is that, a lot of the time you're not necessarily, you're more worried about what issues you're not hearing about than the issues you are hearing about. Because could be just a lot of folks out there who are going through hell and really need help, but they're not getting it. So anyway.
all right, enough of that.
Enough sidetracking here. All right, so the lease have contracts and tenancy addendums. So once the tenant finds a place, they need to lease up, which means signing a lease with a landlord. And when we say lease, we mean entering into a written rental agreement with the landlord. Vermont law allows for oral rental agreements, but a requirement of, Subsidies, Section 8, is that there needs to be a written rental agreement. So the tenant leases up with the landlord and the housing authority enter into a housing assistance payment or more letter salad HAP contract. This contract becomes a part of the lease. And it basically outlines the owner's responsibilities to the PHA. There is a tenancy addendum that's also part of the HAP contract and therefore part of the lease. And this outlines a lot of the rights that protections that the tenant has. An important advocacy tip here is that the tenant can enforce the tenancy addendum, the HAP contract, against the owner. So if the owner, tries to say, for example, terminate the lease in a way that violates the HAP contract, the tenant can move to dismiss the eviction case if it's in court because the landlord didn't follow the HAP contract, the tenancy addendum. And if there's a conflict between the lease itself and the tenancy addendum, the addendum controls. And the rent must be reasonable. That's defined in the federal regulations. The landlord can't charge more rent just because they know the government's going to be paying, most of it. That they need to keep what's called the contract rent or the gross rent. Is it, Bradley?
The gross rent, gross rent.
To a certain limit. So that depends on the location, quality, size, unit type, and age of the contract unit. So these are all like local, geographic sort of considerations and amenities, housing services, maintenance, and utilities to be provided by the owner.
Question.
Yeah.
Have you guys seen any discrimination per se of landlords not being receptive of people recipients of Section 8?
Yeah, it does happen. And so this is sort of maybe you can explain this better, Bradley, but it's illegal for a landlord to discriminate against a tenant because they receive public assistance, but it's not necessarily illegal for a landlord to not lease up enter into a HAP contract. They don't want to.
Yeah. It's tricky. I think that's I'm hearing, that's the second question we've had that's discrimination related that is a touch outside my wheelhouse. Because I don't know how that would play out, and I'm wondering if we can confer with our colleagues who do housing discrimination law project and get something a little bit more in depth. Because it's clear under Vermont law, you can't discriminate based on receipt of public funds.
Right.
And so does that mean they have to lease up? Maybe not, maybe, I don't know. So it's interesting. Renee.
Sorry. Back to my experience. My experience, they, like you said, don't have to.
Yeah.
They just need a reasonable justification for deciding not to.
Okay.
It has to, it's
Okay.
like they have to have a legitimate alternative reason that they can point to and say this is why.
And that makes a lot of sense. And there are a lot of requirements in federal programs that you have to go through, and sometimes, so.
But if they're a good tenant and there's nothing that they can point to, they definitely cannot say it's because you have a subsidy.
Right. right.
That's
right.
totally not allowed.
Yeah, yeah,
And if they
yeah.
do say that, then that's very obviously discrimination.
Right, right, yeah. Yeah, that's tricky. I would be interested in like hearing more in like more details, like, you know, from people who have more kind of like actual, some more work experience about the nitty gritty of that kind of stuff, because I don't. And, but I'm fascinated by that kind of stuff.
Honestly, it doesn't come up that.
Yeah,
often,
exactly, right.
Just-
Yeah.
Thankfully, thank God.
Right, I know, right?
Even when it does come up, those cases are very, very fact intensive and fact specific. And most of the time, the landlord's not gonna do you the service of saying, I'm refusing to rent to you because you're on section 8 or you get
Right.
food stamps. Like, no, it's
It's like.
it's not gonna be that
discrimination
facial.
cases, right? It's like,
Yeah,
No, I have other reasons. And then you have
Right.
to prove that you
Exactly,
don't fight that.
exactly.
that's a
Okay.
whole nother training.
Yeah, that's interesting though. It's interesting. I love doing these presentations because then I also learn what I don't know, you know, and like what's lacking in my experience. And so, you know, that might be something we put together later on.
Okay, so housing quality inspection are the sort of part of the subsidy that regulates how habitable the apartment is allowed to be, or what standards the apartment needs to be kept at in order to continue to qualify for a subsidy. So HUD sets its own minimum housing standards, and that, as you can see, some of them are included here. But basically, the idea is that the Housing Choice Voucher Program is meant to ensure in part that all residents live in safe, habitable dwellings. Sort of mirrors, if you're familiar with the warranty of habitability that exists in state law, housing that is safe and clean and fit for human habitation. Same sort of idea. So if the tenant wants to lease up at a dwelling unit, an apartment, and the place is just not habitable or doesn't meet the housing that the public housing authorities or HUD's minimum standards, they're not going to be able to lease up here unless or until the unit is brought into compliance. And as I just alluded to before, state housing, state habitability and rental housing laws also apply. Perhaps independently, but you know, that those don't necessarily dictate whether the unit is eligible, has to meet the HUD standards, but they often mirror each other. So why do owners have to do this? What's the big deal? Well, the Housing Choice Voucher Program is a federal law with federal requirements. As we discussed before, the federal government has skin in the game. They have a direct interest as to the quality of the housing that folks who qualify for subsidies are able to avail themselves of. So the program helps ensure house tenants and pay owners directly. So owners are the beneficiaries of federal aid. Tenants are also beneficiaries because they're getting affordable housing throughout this, but you know, the owners, the landlords are the one that are actually getting the money from the federal government. So in exchange, they have to ensure that they're providing housing that's safe and, you know, livable. The federal government has also determined that, you know, folks who qualify for federal subsidies are folks who are in need a lot of the time of, you know, some more protections. So affordable housing. Protection against arbitrary evictions. We'll talk a little bit more about like for cause, no cause evictions, enforcement of habitability protections. So some sort of enforcement mechanism to get the landlord to comply and remain in compliance with the housing quality standards.
Yeah, and I think one piece I'll add is about the philosophy of this kind of stuff is that, you know, the federal government sees this as an anti-poverty measure, right? And so it's recognizing that part and parcel of needing affordable housing is sometimes the underlying causes of poverty, right? And so you see that most of the Violence Against Women Act, where there are increased protections for people who are victims of domestic violence and related things, because it's part and parcel of poverty as a broader systemic issue, as opposed to just saying, okay, you know, you have low income, you'll be able to rent just like anyone else. And you might need more protections. You might need someone helping you assert your rights to habitability, and things of that sort. And there might be other things going on in your life that you need some flexibility for. That said, there's not a ton of flexibility for tenants. There's some, but I think that's the picture, right? That's the thought.
I guess another way to put it too is that, just because the tenant isn't paying 100% of the rent doesn't mean that their apartment, doesn't have to be livable.
Right. Yeah. That's absolutely right. Next slide, please. Okay, so setting the rent. This is an interesting little rigmarole that goes into setting the rent. So the rent has to be reasonable, like Eric said earlier. So the contract rent or the gross rent is the rent charged by the landlord. I've always called it the contract rent, but the regs say gross rent. So I say contract rent, that's what I mean. It's the total rent amount. HUD sets the fair market rate for a given area. And the next slide will show you the Vermont rates, but then you can kind of play with the data on your own. And then,
Sorry, can I?
Yes.
How often do those update?
oh, I don't know. That's a good question. That is a good question. I know they set,
2024,
I know they set them yearly.
Okay.
That might
And
be it.
might be just year.
is that just yearly then?
That's my hunch, but.
Okay.
Maybe it's fiscal year?
Okay. Yeah, I guess that makes sense.
Well, that's good. I'm glad that you did that.
And then, the PHA set their payment standard as 90 to 110% of the fair market rate. So and the PHAs need HUD approval to set the payment standard higher. But you can ask for a higher payment standard as a reasonable accommodation. Sometimes you can be successful, sometimes you can't be. And the payment standard will be higher for larger households, need more bedrooms, right? And so, let's look at the next slide, maybe some data. Okay, so this is HUD's fair market rate for a 1-bedroom apartment in Vermont. And so you can see that county by county, there's a huge difference. Franklin, Grand Isle, and Chittenden counties are largely more expensive than virtually anywhere else in the state. There's a lot of difference. And then so how much a given housing authority is going to pay is going to depend on the fair market rate of a given area. So go to the next slide here. So a tenant share of the rent is separate from both the market rate and the payment standard. So right, the market rate's what HUD sets. That's what you saw there. The payment standard is what the housing authority is going to pay for a given apartment. So it could be higher or it could be lower than the market rate, right? And then the tenant share of the rent is a third calculation that is about 30% of their adjusted gross income. It includes tenant paid utilities. And then that's unrelated to either the market rate or the payment standard, right? It's just 30% of their income. The PHA will pay the remainder of the rent up to the payment standard, right? And if the gross rent is higher than the payment standard, so the contract rent is higher than the payment standard, the tenant may make up the difference, but not if the resulting payment is higher than 40% of their adjusted gross income. So the following slide will show a calculation, a rent calculation with someone as $900 per month as their income. So just before we move on, so if your income is $900 a month, times 12 is $10,800 a year. And then 30% of that is $3,240. And then so your 30% of your rate of your income per month is, divided by 12 is $270, right? And so $270 is the tenant's rent, is 30% of their gross income. Let's go to the next slide. Okay, so the gross rent or the contract rent is what the landlord is charging for an apartment. That's unrelated to the fair market rate that HUD sets, right? The landlords can charge whatever they want. There's no price control on that. So that's how much the landlord is charging. Say the payment standard is $1,000 because that is based on the fair market rate rent for a given area. So if housing authorities determine that a 1-bedroom apartment is $1,000 in their area, that's how much they'll pay up to. The tenant share is $270. So that means the housing authority share is $630. So can the tenant be housed there? Yes, the tenant rent is 30% of their income, right? And that's what we see similar calculations as the gross rent is increasing. So on the next slide, on the next column, the gross rent's $1,000, right? So this landlord's charging $1,000 for a 1-bedroom apartment. The payment standard is $1,000. The tenant share stays the same, even though the rent's higher, the tenant share stays the same. The PHA is paying $100 more, right? And that's fine. The PHA will do that. A different apartment's $10,050, right? Okay, so the payment standard is $1,000. The housing authority is not going to pay more than is not going to pay beyond the payment standard, right? And so anything that goes beyond the payment standard, the tenant has to pick up, right? And so the tenant share of the rent is $270, so the PHA share is $730, up to the payment standard, so pay up to the payment standard. The rent's higher than the payment standard, so the tenant has to pick up the rest. The tenant can still rent there because their share of the rent is 35% of their income, right? So they've picked up a little bit extra, their rent's higher, but it's still fine. We look at the fourth apartment at $1,100 is the contract rent. Payment standard is still $1,000. The tenant share is $270. The PHA will only pay up to the payment standard. And so the tenant has to pick up an extra $100 in this situation. And so because the contract rent is higher than the payment standard, the tenant's picking up an extra $100 in rent. And then we look at the calculation, the tenant actually can't rent here now because their share of the rent is 41% of their income.
They don't even have the option.
They don't have the option, right? They cannot rent there unless there's a reasonable accommodation related reason of why they need to rent there, right?
And I can rent nowhere else. It's not a legitimate.
Exactly, unless it's a reasonable accommodation related rent, so it's like if you need a first floor apartment and that's the only first floor apartment after 10 places that you've looked and you're out of time, let me do this. I think that would be a good reasonable accommodation request. But yeah, and I have been in situations where it's been 41% and the housing authority has said no, and the tenant couldn't find another place to go.
So how was the PHA calculated again?
So the PHA share is calculated, so the PHA share is, the tenant share is calculated first, so it's 30% of their
Right.
income.
Yeah.
And then, they'll pay up to the payment standard, and that's how the PHA is paid, right? And then, so if the contract rent is higher than the payment standard, the tenant has to pick up the rest.
Could you negotiate with the landlord? And
Yep.
say, hey, I'm at 41. Can we just drop this by
yep,
$10?
Yep. I've actually had that been successful.
Yeah.
I've had a landlord drop the rent by $3.
Yeah.
And they got in, and which was ridiculous.
If they would have said no, then that would have been even more.
Well, it was ridiculous at the housing authority. I mean, but they're like, look, it's a HUD guideline. They're like, we don't have the discretion to, even if it's 40.01, whatever it is, we don't have that discretion. We don't have the legal authority to grant this unless there's a reasonable accommodation related reason.
Mhm.
And so that's up to your client, and then you go to the landlord and say, can you please just drop this $3? And they do.
That's
So
why,
I mean, I should say that they do, but in this situation, in my experience, they did.
I mean, that's why it'd be more ridiculous if the landlord said no, because they do have discretion.
Well, yeah, but they're also getting guaranteed income too. And it's really smart for landlord. I think it's smart for landlords to lease up in that kind of situation, because it is pretty much guaranteed income if you follow the HQs. I know it's super complicated, but it's like once you get a hang of it, it's kind of interesting. And every now and then we do get questions about rent calculations.
Yeah,
And
they come through.
All right, next slide. So we're about halfway through. We probably need to pick up the pace a touch. And this one's still rent increases. The landlord must notify the public housing authority of rent increases at least 60 days before it comes to in effective. That's the same as Vermont law, so there's no additional requirement there. But they have to notify the landlord also has to notify the tenant of the increase too, but they also have to notify the PHA. The PHA will not approve the rent increase if it increases rent reasonableness standards. So it has to be comparable to other units that are similarly situated. the landlord can't raise the rent during the initial lease term. I think that's pretty common under the vast majority of leases, just lock the rent in at a certain rate. And landlords don't need to sign a new lease or HAP contract to continue to effectuate a rent increase, right? It can just be like regular landlord-tenant law. In Vermont, you can, if your initial lease expired and rolled over or what have you, you can still raise the rent with a 60-day notice. So that's pretty much the same thing. They just have to notify the PHA, and then the PHA has to approve the rent increase. And more often than not, they will, unless the rent increase is something that is unreasonable. Next slide, please. There's annual recertifications and biannual inspections. And so participants need to recertify annually. They'll fill out paperwork and do an interview. Failure to recertify can lead to termination of assistance. The home must be inspected again for housing quality within 24 months of the initial lease term. The family must be present for the inspection, which I wasn't familiar with that requirement, but they have to be present for the inspection unless there's a reasonable accommodation related reason for not. And the family may request an inspection if they believe the unit's conditions have deteriorated since they moved in. Go to the next slide here. Housing quality, they call it the biennial inspection, right? Once every 2 years, the public housing authority will come in. Some housing authorities will do it more often, but they have to do it once every 2 years. And if the unit fails, the landlord refuses to repair after a 30-day notice period, which doesn't happen often, but every now and then it does. So if the unit fails, the public housing authority say you have 30 days to do this. The landlord doesn't do the repair and doesn't request an extension. The public housing authority may abate the HAP contract. So that's a term of art, meaning that they're not going to pay their share of the rent. If the landlord fails to fix the issues, the PHA may terminate the HAP contract, right? PHAs can abate the HAP contract for up to 90 days. It's more guidance than regulation based. I think this is in like the HUD handbook. And the HAP contract automatically terminates after 180 days after the last payment to the owner. And then after the abatement period, after the abatement period, the PHA may terminate the HAP contract. So basically what this means is if the housing fails a inspection, the PHA will notify the landlord. The landlord fails to do it and fails to respond and fails to ask for an extension, which they will give if there's a reasonable grounds for it. The landlord fails to ask for an extension to fix the issue. The PHA will stop paying their share of the rent, and then could terminate the HAP contract if it goes on. The tenant still has to pay their share. And so if the tenant doesn't pay their share and doesn't notify the landlord of holding or what have you, the tenant could find themselves in eviction, but the tenant is not responsible for the housing authority's piece if it's abated, right? Let's go on to the next slide here. So the landlord cannot require the tenant to pay a suspended HAP payment or retaliate against the tenant for that suspension, right? That doesn't mean they won't, say, hey, you owe this, here's my notice, but the tenant will have defenses if they do that. Tenant must still pay their share. As a rule of thumb, and in the PHA admin plans that I reviewed for this presentation, PHAs will try not to terminate the HAP contract until the family has found alternative housing. So in the background, the PHA is working with the tenant saying, look, if he's not fixing this, you can move. And we're helping you look for a place to go, especially if the issues are serious enough to abate the HAP contract, because this isn't just there's a little bit of mold in the bathroom. This is like serious, like electrical issues, health and safety issues. But, if the tenant can't move or doesn't move and the PHA terminates a HAP contract, what they'll do is they'll issue the tenant a new voucher. And what did we learn about the vouchers is that you got to use or lose it, right? And so you'll have 60 days to lease up and then with an extension. And then long story short is if the PHA is abating a HAP contract, the landlord is not responding at all. The advice is to the tenant to work with the landlord or work with the public housing authority to try to find somewhere else to go.
And all the housing authorities have housing retention folks. You know, these are people that work directly with tenants to help them keep and maintain housing. So, you know, another practice to engage with those folks. So,
All right, and the next one, evictions to you, Eric.
all right, yes. So now we're in a situation where we're looking at if the tenant is faced with termination from their subsidy or eviction from the unit. In subsidized housing cases, special rules and protections apply. They don't otherwise apply in just a regular private landlord tenant situation. So in subsidized housing, tenants can be terminated from their subsidy, the Housing Choice Voucher Program, for failure to follow their what's called in the regulations as family obligations. These are material terms of their lease, you know, basically like the material lease terms. Simultaneously, tenants can also be evicted by their landlord from the dwelling unit for violating their lease agreement. Of course, what's the most common one? Non-payment of rent. So that's a grounds for termination from their subsidy and also cause for being evicted from the apartment. So one biggie, this comes up quite frequently. And it's an issue spotting thing for, you know, folks who are doing eviction defense cases. The family must give the PHA a copy of the notice, but the owner has to also contemporaneously, and that's provided for in the HAB contract, notify the PHA as well. So what does that mean? It means when the landlord sends out the eviction notice to the tenant, at the same time they do that, they have to send a copy to the housing authority. And usually you're looking for like a carbon copy, some sort of notation on the notice that says CC, Vermont State Housing Authority. If that's not there, potentially the case can be dismissed because if there's no indication or reliable indication that the landlord complied with that requirement, that could mean that the landlord hasn't actually terminated the tenancy within the bounds of the law. These are separate processes, but often occur in tandem, which makes it pretty difficult from an advocacy perspective, and not to mention difficult for the tenant, but you're basically fighting two battles if that's what's going on, defending against the subsidy termination and defending against the eviction. So to evict a tenant, landlords must of course follow normal Vermont law for evictions, but there are also federal regulations and rules that come into play. They have to comply with the HAB contract, the tenancy addendum, the CARES Act, and I think the CARES Act was discussed in the landlord tenant eviction presentation earlier, so we all know what that is. During the lease term, which is usually the first year, the initial when the tenant and the owner sign the rental agreement, the owner can only evict the tenant for cause. And what this really means is, material violation of the lease, such as non-payment, unauthorized occupants, criminal activity, drug activity, things of that nature. At the end of the lease term or for successive, renewals of the lease term, whether it's just like the lease continues, no cause terminations are generally allowed. However, being evicted for no cause won't in and of itself mean that the housing authority is going to terminate the subsidy. Why? Because the tenant's not at fault. It's no cause. So for cause evictions, there are rules that apply to what kind of notice the tenant is given that are in conjunction with, but also go beyond state law. The notice must state the reasons specifically. And this means, as you can see from the HUD handbook here, state the reason for the action with enough detail to enable the tenant to prepare a defense. Typically, what this means when a judge, for example, is analyzing the legality of the notice, they look at things like specific instances, dates, specific factual details rather than blanket statements like you harassed someone. And of course, different judges will have different standards for what is specific enough to prevail in a motion to dismiss. But basically, if the notice is just saying, in conclusory terms, you violated your lease or you harass other tenants, or just quotes the language of the lease and says you violated this, that's not gonna stand up to scrutiny. So on the flip side, we have the termination from the subsidy, the voucher. The housing authority may decide to terminate the tenant's assistance for violations of family obligations. We mentioned that before. These violations must be serious or repeated. Also unauthorized guests, subletting, failure to submit recertification, smoking, quiet enjoyment, cleanliness of the unit, hoarding. These are the most common reasons we see for terminating subsidies. And of course, reasonable accommodation requests can be made to defend against the voucher termination. I mean, hoarding, is a big one where there might be a disability nexus or some sort of basic, defense that could be made along those lines. Bradley mentioned this before, but the turnaround time to request an appeal once the tenant is given notice of the termination is not long. It's only 10 days. That is a very short amount of time. And we get so many folks who call us on our helpline saying, my voucher was terminated. They said they're gonna end my voucher. Like, when did you get this notice? Oh, a month ago. And in that case, you're either out of luck or you need a reasonable accommodation request or something along those lines to preserve their rights. Yeah.
Just curious, what kind of evidence does the PHA need to provide for justification of these violations?
Good question.
Is there any kind of requirement other than just stating?
Well, so they don't need to give direct evidence with the notice. The notice just has to set forth the grounds. However, if the tenant appeals the termination.
Right, on the appeal.
Yeah, on the appeal, then the housing authority, I don't know if there's any clearly defined standard in the regs, but I don't believe it's any more than preponderance.
I don't think
Right.
I don't think it's more preponderance.
Yeah, so.
Interesting.
And, drug-related, violent, or other criminal activity that threatens the health, safety, or right of peaceful enjoyment. Offsite criminal activity is a sort of question mark here because sometimes this comes up and there's no clear, I think, bright dividing line, but there's a really good argument that, at least from the perspective of defending tenants, that can be made that if the alleged activity had no relationship at all to their tenancy or did not occur on the premises, it should not be subject to a termination.
And while we're mentioning evidence and things, because I don't know if we talk about it, but things like hearsay and rules of evidence are definitely relaxed for the housing authority. So that kind of stuff can come in and be at issue. I've had defended my fair share of tenants in those kind of proceedings, and that can be a challenge.
Yeah, sometimes when it comes to hearsay and stuff like that, you'll see, evidence that can be reasonably relied upon by prudent persons, that kind of standard. So,
and we're about 15 minutes left. So if we can cruise through these next slides, because I think it's basically just listing a lot of stuff.
Yeah. So try to be quick here. Administrative plans, check the admin plan. They may be more generous than federal law. Check federal, see what rules apply. So there are two kinds of appeals, as it were, that can be invoked in the context of subsidized housing: informal review and informal hearings. So an informal review is a process where the decision is reviewed by someone who did not make the original decision, and the applicant can submit objections. And then basically the housing authority takes another look at it and sends notice back to the applicant whether or not they approved the informal or overturned their decision. And then there's informal hearings, which we'll talk about a little bit later. So what's subject to informal review? Denying assistance, denying of being on the wait list, denying or withdrawing a voucher, refusing to enter a HAP contract, refusing to port a voucher. These are all subject to informal review. So the tenant or the applicant, I should say, can say, hey, I disagree, take another look at it. Here's why, and they'll take another look at it. Not subject to informal review. I won't list all these for the sake of time, but these are the things that are not subject to informal review.
And hearings, very similar. Basically, when you're being terminated from your assistance or your assistance is changing in a substantial way, you're entitled to an informal hearing with that slightly heightened protections, heightened due process protections, not as much as court, but slightly heightened due process protections. The next slide here. And then, so this is a big issue because there's mandatory and discretionary terminations, right? And so, kind of how we've been talking about is sometimes the housing authority will say, I don't have the discretion to do this. We got to do it, right? Even when you're like, it's so close, come on. but there are some situations where the housing authority just doesn't have the authority to say, we're gonna look the other way or make an exception, again, without a reasonable accommodation, right? I think these kind of things are probably not even gonna be, well, no. Sometimes criminal activity, alcohol abuse that would threaten other residents and things of the sort, you could make a reasonable accommodation request. But if someone is being terminated or evicted for these reasons, serious violations of the lease, including non-payment, there could be a reasonable accommodation release related reason why you're not paying the rent. That could save your voucher. You might still get evicted, but you could save your voucher. Any member of the family fails to sign a consent to releasing information. That's kind of a big one. Sometimes folks don't want to release certain information or sign releases of information so that the housing authority can get some information about their eligibility. That's a mandatory termination, if that doesn't happen. Let's go to the next slide. Mandatory terminations, the family has to submit evidence of citizenship, failure to meet eligibility requirements for individuals enrolled in higher education. Those are really interesting cases. I've only had one in 10 years of practice. And then the PHA may deny or terminate assistance based on restrictions or net assets and property ownership when required, or must deny or terminate for income related things. All other terminations are discretionary, right? Like no cost, virtually anything else is discretionary. But a PHA may terminate a housing choice voucher even if an owner waives back rent in exchange for vacating on a certain date. So this is kind of like a lot of our practice that you'll find out in rent escrow is that, we'll say, okay, we can settle the date, we can settle this case if you move out and on 30 or 60 days from now. If you agree to waive the back rent, put a bow on the case for today and call it good. And, sometimes landlords will agree to that. Your voucher could still get terminated in that situation, even though you're not actually evicted from the home at that point. Or you're not ordered evicted, you're agreeing to an eviction. The housing authority might still terminate your voucher, and in which case you'd have to appeal that determination and ask that they don't do that.
And I'm sorry, I don't mean to slow us down, but why would they do so? If you're agreeing just to leave as opposed to actually go through with
Good question.
the judgment?
Yeah, so
You're not
that's,
stipulating to judgment there, right? You're just agreeing to.
you're agreeing to, you're stipulating to a writ of possession.
Right, you're
yeah,
stipulating
yeah,
to
right,
possession
right.
if you don't move out.
Right.
But only if you don't move out.
Right. Yeah. So, it can be tricky. I think some housing authorities will just look at failure to pay rent as a violation of the family obligations. And, some of them just want to, they don't have a lot of, I have heard directors say they don't have a lot of patience for people who don't pay the rent. And so that might be part of it, because I think in the past, public housing authorities in our neck of the woods have been a little bit more forgiving if the landlord is forgiving. And so they won't proceed with the termination if you come to an agreement with the owner, right? But sometimes they have been moving in the direction of taking a harder line because it is an independent violation of your own family obligations if you're not paying the rent. And so you're violating program rules.
Even if you don't stipulate to the fact that you had unpaid rent?
Yeah, well, I don't know.
What if you just don't agree?
Yeah,
Just say, we're just agreeing to go our separate ways.
Yeah, well, that would be interesting. I wonder, because we've had,
They're waiving back rent.
right. Stipulate that there's no rent owed.
There's no rent.
I wonder. Well, I guess, we might be able to chat a little bit more about this later, but that would be interesting. How can
you get around it?
And it would be worth exploring that to see if we can draft our stipulations in a different way.
I think it's worth taking a look at, but the problem is that once the notice goes out from the landlord and the housing authority sees that the tenancy is being terminated for non-payment of rent, the fact that the parties later settle the case in the PHA's eyes doesn't absolve the tenant of, or doesn't cure the violation. They, in the PHA's eyes, failed to pay the rent. We don't care that you're agreeing to move out. you know, unless you can prove that you weren't at fault or didn't pay the rent, you violated your family obligation. So, you know, this is, yeah, it's become a practice issue for us.
Yeah, and
A lot of the landlords I know don't necessarily want these tenants to lose their
right,
voucher.
that's exactly
And I'm
right.
happy to work with them
That's exactly
to,
right.
to try and make sure they don't, but
Yeah.
if they're not paying their rent, they're not paying their rent.
That's exactly right.
They're
Yeah,
Kind
yeah.
of in that
Yeah.
tough spot.
Yeah,
Yeah.
because we work with, you know, I mean, obviously we work with a lot of private attorneys who do, who work with housing authorities and things of that sort, and I think this kind of surprises them too.
And really quick, I know we're running out of time, but really, really quickly, this also comes up, even if in the stipulation, because I've negotiated a lot of these before, even if in the stipulation, it says the landlord will agree to sign the paperwork
Yeah.
certifying that the
Yeah.
tenant is in good standing,
Yep.
I'm moving out. PHAs still don't care.
Doesn't care.
Yeah.
That's so wild.
Yeah, well, it's funny too, because like I said earlier, I got my practice started in California doing landlord tenant law, and the PHAs out there were very strict. And then when I came out here, the PHAs were not as strict. I was like, wait, why aren't they terminating the tenants? Oh, this is great. This is wonderful. I think they started doing it.
I think someone from California.
I jinxed it. I was like, hey, you guys are so nice.
What's going on here? You guys are getting away with murder.
I was like, these guys are great. I love Vermont. I was like, no, don't change. All right, let's go on to the next slide. So I'm gonna go to VAWA protections. A person cannot be denied, terminated, or evicted from federally subsidized housing due to domestic violence, dating violence, sexual assault, or stalking if the applicant or tenant otherwise qualifies for admission, assistance, or participation or occupancy. So covered housing providers applies to PHAs and owners of those units, right? And so, and VAWA itself kind of stipulates, you know, who is and who is not covered. But if you're a landlord in the HCV program, you do have to, you know, follow VAWA, right? And so if you're evicting someone because there's someone living there that you don't want living there, but it's domestic violence related, this person's been trying to get that person out and they just can't. That might be a defense to the eviction, both a subsidy termination and the eviction. Non-payment gets a little trickier, but because there might be a non-VAWA related reason for non-payment. But VAWA protections do apply in the landlord-tenant context in an eviction proceeding, even when it's a private owner who's, you know, contracted with the public housing authority. Covered housing providers need to give notice when denied assistance, when providing assistance, and with any eviction notice or termination of assistance, right? So next step. And so the HUD guidance is really good. So I put this here just because I wanted us just to take a look at it. You know, on the surface, this is directly from the guidance. On the surface, adverse factors may appear unrelated to domestic violence, dating violence, sexual assault, or stalking, and may present legitimate reasons for denial, termination, or eviction. However, the presence of an adverse factor may be due to an underlying experience of domestic violence, dating violence, sexual assault, or stalking. An adverse factor may be present during much of an abusive relationship, or it may be present only when a victim is attempting to leave or has left the abusive relationship. And so it's one of those things where that, like, HUD is hammering home that VAWA is an anti-poverty statute, right? VAWA is taking a larger look at those systemic root causes of what puts some people in a bad situation that they find themselves in. I think that that's super powerful language. And if there are situations, I've been in situations, even in Vermont, I've been in situations where, you know, maybe I can't say something to opposing counsel because, you know, my client won't let me, and that's fine. That's absolutely fine. But I'm asserting a VAWA related defense and trying to give this person time to get out of a bad situation. And it's good that we have HUD guidance to help us if we can't negotiate something like a stipulation or what have you. And it's good we have this HUD guidance. I think it's more, in my practice, this more comes into contact with PHAs because PHAs might be more aggressive in terminating assistance for things like you have an unauthorized document, you have a dog, you have, you know, this, that, or the other thing. one anecdote is that I had a person who was getting mail from her ex-spouse at her home, and the Public Housing Authority terminated her for that reason. And she's like, I kicked him out, and he's just getting mail here, and I can't stop him. And it's literally a car magazine, like, or something stupid, right? Like, it wasn't even like a utility bill. It was like a car magazine. She's like, I don't know how to get this to stop. I kept writing return on the thing. And she's like, I'm trying not to talk to him. I'm trying not to get rid of him, but it's like, I don't want to call him. And so,
What speech do you even know?
I suspect it was some kind of inspection or a social worker that came over to help the person and notice something. They might have disclosed it themselves unintentionally sometimes, because they might say things like, "Oh yeah, he still gets mail at my home," which is actually like in the rules saying other people can't get mail at your home. And I've had clients disclose that information, thinking that it was not as serious as it is. And so it's interesting. So it's a lot broader than you think it is. Next statute, some examples of VAWA related things. I'll let you read that at your leisure. And some hearing pointers. If you have RA grounds to ask, if there's a VAWA issue, raise it. There's limited discovery and things of that sort. Let's go to the next one here. Okay. And so we are at, what time is it? So let's take 5 minutes to go through LIHTC, Eric.
I'll try to do it in less.
Yeah.
We could try to boil it down to, we have like 5 or 6 slides on this, but we're basically out of time. So LIHTC is a program where a housing provider, landlord, owner, housing developer gets tax credits from the federal government, tax breaks, in exchange for renting a certain amount of units in their properties to folks who are lower income. Typically, this means 50, 60, under 80% of AMI, as long as a certain amount of units in a dwelling or apartment building are set aside for folks who meet those income criteria, the landlord gets the tax break. So in this case, it's not the tenant necessarily applying for the subsidy because the subsidy goes with the unit. It's a covenant that runs with the land, but the owner has to make a certain amount of apartments available to folks who are low income in order to qualify for the subsidy. So unlike Section 8, the government in this case is not necessarily involved on the tenant's lives. They don't have to, apply directly to the government for the subsidy or the dwelling. It's mostly the landlord getting the tax break from the government in exchange for providing the housing. And the rent is not directly tied to the tenant's income like it is in Section 8 or other subsidized situations. It's tied to factors related to the dwelling unit. I'll let you read over everything else at your leisure, but that's basically the bare bones LIHTC. And tenants can't be evicted for no cause. The landlord has to have cause to evict. Those are the main ones.
All right, and then for project-based Section 8, it's similar to HDBs, but it's attached to the property, not the tenant. Rent is still typically 30% of the tenant's adjusted income. So LIHTC, the rent can actually be much higher than 30% of the tenant's income. That's less likely in project-based Section 8. Tenants must be very low income, less than 50% AMI. And then the owners must make some units available for extremely low income households. Next slide here. Owners have tenants typically do not deal directly with a PHA. They apply and recertify with an owner. And owners enter into a HAP contract with the PHA and then their own lease agreements with the tenants, and things of that sort. Let's take the next slide here. And owners may choose to not renew a HAP contract, in which case the tenants might get an enhanced voucher or or an ability to move to a subsidized unit and things of that sort. And if that happens, there's some transferring rules that are cited there. Next slide here. And then you want to finish with some special eviction protections, Eric?
Absolutely. So, just like we've seen before, the owner must contemporaneously serve a tenancy termination notice to the PHA. Otherwise, the notice could be void or the case could be kicked out. A VAWA notice also has to be served, must be contemporaneous. And just like you've learned with the CARES Act, at least 30 days notice must be required. And this is provided for in the rules of civil procedure now. Two, the rules of civil procedure require the landlord to certify that they're either complying with the CARES Act or it doesn't apply. We've gone over specificity before, same kind of rules apply here. Pre-litigation hearing is afforded as a matter of right if you're being evicted from project-based housing, subsidized housing, which means that, you know, due process requires your appeal rights must be stated in the notice. You have 10 days to request an informal hearing. Good cause tenant protections also apply here for the first year of a HAP contract with Section 8. And as we've gone over before, the tenant can enforce these provisions. And I think that is it.
All right.
We only went 5 minutes over.
Cool. So if there are questions, feel free to ask them, but if you need to step off for a lunch break, we'll meet back here at 1 for rent escrow. But any questions, anyone? All right, we'll meet back here at 1.